Something's up or not up. Did husband's impotence serve to annul marriage? The British Columbia Court says yes. Under long-established Canadian laws spanning more than 150 years, marriage can be considered annul or declared legally voidable, where one of the spouses could claim the other was incapable of consummating the marriage. The reason could be either psychological or physical. All that mattered was that one spouse was incapable of engaging in sex on the date of marriage or any time afterwards. In this recent British Columbia case, the court was asked to apply those long-established laws to annul marriage between a wife and the husband on the basis that the marriage had never been consummated due to the husband's impotence. It seemed that the wife wanted an annulment rather than a divorce for religious reasons. She and the husband had not lived together for about a year, and neither of them wished to be married to each other any longer. The BC court was accordingly asked to determine the legal question of whether on the evidence the wife had satisfied the burden of establishing that the marriage contract she entered into with the husband was void to his inability to complete an essential term of the contract, namely engaging in sexual intercourse. In the terms of the meeting of this threshold test, the court offered some interesting legal history on the quality of the evidence needed. For 17th century trials, proceeding before the French and Spanish courts, for example, the act of copulation had to be attempted before a jury of medical professionals, before impotency could be proven. There was also a Canadian legal precedent to suggest that the impotency had to be considered permanent. If there was any possibility that it could be cured, then the marriage would not be annulled in law. However, the BC court concluded that these were onerous thresholds, were no longer in step with the modern day approach, which called for a lower evidentiary standard. The court said it was satisfied that the extremely strict standard of proof required in earlier centuries resulted from an apparent horror of impotency within the cultural norms of those times. The court was satisfied that it was a strictly standard of proof is necessary or appropriate today. Contemporary law required that the wife establish one or both of them were incapable of engaging in sexual intercourse due to a psychological or physiological incapacity. With this test in mind, the court tendered evidence which consisted of affidavits from both parties. First, the court rejected the wife's suggestion that the husband be ordered to submit to the medical examination to determine his ability to have an erection. The court noted that the husband had never actually refuted the wife's allegations to his impotency, and there was already sufficient evidence in the affidavits for the court to be able to make a ruling. Next, the court cataloged some of the relevant aspects to the spouse's relationship. They had never lived together prior to getting married. As newlyweds, they tried to have sex about twice a week for more than 6 months. But each time the husband was unable to obtain or maintain an erection to allow penetration. The wife asked him to see a doctor, but he kept putting it off. Eventually, one doctor told the husband that there was nothing wrong with him, and he refused to get a second opinion. The couple stopped living together a few months later. In the end, based on this evidence, the court ruled that the wife had sufficiently established her claims and that the husband was unable for physical or psychological reasons to consummate the marriage on the date of marriage nor any time thereafter. This was despite the husband's affidavit evidence that he had now had a new girlfriend with whom he claimed to have sex with regularly. The court did not contradict the wife's evidence that this husband was unable to have sexual intercourse with her. The court declared the marriage contract between the wife and the husband to be null and void. You can like this video, comment below in the comment box, or share it, or subscribe to our videos in the future. Thank you for watching today. I'm Russell Alexander.